This program is brought to you by Emory University.
I'm going to welcome you back for the continuation of our program, and we'll turn to a panel to discuss judicial ethics. Really could not have constructed a better panel of judges with great perspective on this, and a great moderator, really who's taught us all any skills that we have at moderating, Rich Reeves, who's the Executive Director of the Institute of Continuing Judicial Education. Rich is all the way there on the right. We also have with us to his immediate left, Judge Cassandra Kirk, again, who you've met already today, the Chief Judge of the Magistrate Court of Fulton County. To her left, we have Judge Bonnie Cheshire Oliver from the Northeastern Circuit Superior Court. And then right here immediately to my right, Judge Robert Rodatis, the presiding judge of the Gwinnett Circuit Juvenile Court. So I hope you'll join me in welcoming them, and we'll turn to them for their expertise on ethical considerations in this subject.
Thank you very much. We'll look forward to this opportunity to share some perspectives with you. We'll begin by informing the folks in the room who may not be aware of it that the 6 classes of trial courts in Georgia have approximately 1,600 judges in them. And when you add the appellate court judges, the administrative law judges from the Office of State Administrative Hearings, the Workers' Comp Board, and Department of Labor, you have about another 100 judges, all of whom exercising adjudicatory responsibilities within Georgia government are subject to the Georgia Code of Judicial Conduct. That Code of Judicial Conduct was revised last year, effective January 1, this particular year. And for the most part, I think it is very, very, very fair to say that those 1,600 to 1,700 judges are truly conscientiously mindful of their obligations. And one of the things that they seem to be very conscientiously mindful of is that they have boundaries that they need to observe. Boundaries with regards to the information and data that they take into account in their decision-making. Boundaries with regards to how they can communicate with others, particularly others within the courthouse and the courtroom, when they are dealing in the context of adjudicatory and dispositional decision-making, as well as boundaries in dealing with wider members of the legal and civic community, the law enforcement community, the local bar associations, local treatment organizations, the media, the general public. And so we'll be talking today, at least in the context of the first 3 questions that our panelists are going to be given an opportunity to respond to, about boundaries and how our judges see optimum professionalism in adhering to the boundaries that are directed by the Code of Judicial Conduct. And here's our first question to go to the panelists. It actually came from one of the participants in this meeting. It was sent to us, I believe it was Tuesday morning, and it was then emailed over to me from your planning committee members. And so I said, well, what the heck? Why don't we just throw it directly to the panel instead of using contrived hypothetical scenarios? The question, as I understand it, came from a juvenile court judge, and it wasn't real clear as to whether the question was coming up in the context of an initial hearing questioning whether or not there should be a detention, or perhaps it was a full-blown adjudicatory hearing. But here it is. When the court is presented with a case involving juvenile age prostitution, in which the judge perceives that this alleged lawbreaker also might be a victim of some human trafficking enterprise, what options are available to the court for getting the prosecutor to widen its view of the circumstances surrounding this case? That's really a fairly simple scenario, and I appreciate the person who sent it in. I hope that person is still in the room so that they'll at least get the benefit of what our commentators will say about it. I'm going to ask the commentators to bear in mind a couple of things about the Judicial Professionalism Code as they think about the answer to this question. Rule 2.10 of the new Code of Judicial Conduct directs that judges should not make any public comment that might affect the outcome or impair the fairness in connection with a pending proceeding or with an impending matter. So that's a restriction on public comment. And that same Code of Judicial Conduct rule goes on to direct that judges not make any non-public comment that might substantially interfere with a fair trial or hearing. So given the simple scenario and the question, what options are available to the court, I'm going to ask Judge Rodatis to be our initial commentator because he's a juvenile court judge and this question came from a juvenile court judge. Judge Rodatis?
Am I on? Okay, great. First of all, I want to note that Rich used the term simple at least 10 times in getting ready to hand me a question. First of all, I've seen the opposite of what this question asks, and that is, do any of you do CJIS cases, Special Juvenile Immigration Status? One of the things you have to prove to get on the path to citizenship is that the child would be in danger if they had to return to their native country. And I've seen the lawyer put up that this child's brother was murdered in front of him. This child was approached by a gang who wanted her to prostitute herself or be involved in drugs, and have the judge say, well, where's the arrest report? I'm not going to find that this child would be in danger. You haven't presented enough evidence. Well, on the other hand, if I were to think that somebody might be involved in trafficking, I think I can open that door that Rich suggests the prosecution would have, not by doing anything outside the boundaries, but by just doing my job. 95% of our cases end in pleas. As part of a plea, the judge or the prosecutor asks a number of questions. How old are you? What country are you from? Do you speak English? Do you need a translator? And the last and most important question is you've got to establish that there is a factual basis for the plea. So in a case like this, my last question to the child would be, tell me what happened. Where were you staying? Who was paying for that room? Just asking the questions to get the factual basis for the plea established can open the door to that investigation. And I'll have to say, our prosecutors and our police are very well trained. They're usually 3 steps ahead of me, and there's always a representative of one of the task forces there when we get one of these cases. The second thing is, if I put a kid on probation, you're going to have a probation officer monitoring that child. They have to report in. They have to do substance abuse testing. And one thing our probation officers do, and I suspect most juvenile court probation officers, they monitor the social media to see if these kids are posting things online or on these websites that would lead to one to consider they were involved in human trafficking. The last thing, and this is just different for juvenile court than our other courts, we have a special magic bullet. We can deprive a child. We call it dependency now. But if I got a child that's in front of me and she says, Mom and Dad live in San Diego, but they don't have a phone, so we can't call anybody, that child is deprived without proper parental care and supervision. And we can put them in the custody of DFACs, who then can try and work, as our probation officers can, to get them in one of the really good programs that are out there to address this issue with young people. Only downside is, with the way the laws are, we're at a real loss to hold a kid in a secure facility until we can get them into one of those programs. Before you go through rehab, you got to go through detox. And we need to break that connection, then get the child into that program.
Rob, thank you very much. Judge Oliver, you have been a prosecutor many years back now.
No, never a prosecutor.
Oh, my mistake. Before you were a state court judge, I thought you were a solicitor. Okay, but regarding what Rob has said, do you have any follow-up thoughts?
Well, juvenile court judges have a unique position because they're the fact finders. And as the fact finder, if they believe that the defendant, I'm going to call it defendant, I know it's not called defendant, G, but is a victim, they could dismiss the charge. If they believe in a police situation that the agreed-to sentence is not in the best interest of the juvenile, then they can terminate the case. They can accept the admission and delay the disposition in order that the parent and child cooperate with the guardian ad litem, which I think is probably a thing that would be routinely done in a situation like this where the judge perceives that there's some victimization of the juvenile, and have them undergo these assessments that we previously talked about and do some more in-depth investigation before the judge determines what the proper disposition would be in this instance. And I spoke with my juvenile court judge, and she said that they have even had situations where they suspect the parent as the trafficker. And so the juvenile court can then order a DNA because this person is claiming to be the parent to make sure they are actually really the parent. And if as Judge Rodata said, if the child lacks the proper parental supervision or you suspect that, then the judge can place the child in de facto custody. And it was very informational for me today to learn of all of the resources that are available and that could be used in these assessment tools to see, rather than, summarily doing something with somebody that you suspect may be a victim, there are assessment tools available that we can refer them to undergo that assessment and determine whether or not they actually are.
Thank you very much, Judge Oliver, and you've really tipped the tenor of the discussion towards the next question. Same factual scenario, except adult court. That is, we have an adult criminal defendant / putative victim. The particular rule that we would ask you to bear in mind from the Code of Judicial Conduct in responding to this question would be that Rule 2.9c says judges shall consider in making adjudicatory decisions only the evidence presented along with facts that may be properly judicially noticed. The judge cannot personally investigate for facts, and the commentary to this rule says that declares that to be neutral and detached, the judge cannot be concerned about personally augmenting cases beyond those items that have been properly presented or may be judicially noticed. As our adult court, superior court judge, do you see any form of difference in terms of the discretion and the resources and the options available to you?
Yes. Most of the time we're not the fact finder in felony criminal cases. Sometimes they'll opt for a bench trial, but it's rare. And 90% of our cases close by negotiated pleas. Even though in plea scenarios we receive evidence in determining, whether or not we'll accept the plea, they have to lay a basis for the case. And you can refuse to accept a guilty plea. If under that same factual case I perceive that the defendant may be a victim, I can refuse to accept the guilty plea. I can, if it is a jury trial and evidence has come out that causes me to perceive that the defendant may be a victim, what I can do, whether requested to or not, is to instruct the jury properly, and there is a defense under Georgia law of coercion. The instruction on that defense is that a person is not guilty of a crime except murder if the act upon which the supposed criminal liability is based is performed under such coercion that the person reasonably believes that performing the act is the only way to prevent his or her imminent death or great bodily injury. Now, of course, the evidence would have to support that charge, but in these cases where there's a perception that there's some victimization, I'm imagining that there's going to have been some evidence to support that perception. Also, we can craft sentences if it is a plea or a guilty verdict, such that a condition of the sentence would be that the defendant, who we perceive may be a victim, get services, support services available to victims, counseling, maybe even get this assessment and send them for support services. Of course, we can also, and do frequently, as a condition of the sentence, order that they have no contact with X, Y, Z. And if, we perceive that there's a trafficker, we can order no contact with that person in any way, shape, form, or fashion. And we can delay the sentence and ask for an assessment before we actually impose a sentence to determine the best case scenario. And that way, if we perceive that the defendant might be a victim and there's either a guilty plea or a guilty verdict, we can get the assessment and have some validated information as to whether or not that's true before we impose a sentence. And so those are just some of the things, options available in felony criminal court.
All right, Judge Oliver, thank you. Judge Kirk, you might see this same scenario in a bail setting hearing or in a preliminary hearing. What options would be available to you in that adult criminal context?
And so I think the first thing you need to look at is figure out what your role is. You need to determine in what type of court you're sitting. That means, is this traditional first appearance? Is this a preliminary hearing? Or is this an accountability type court? I don't believe there is anything that prevents me from asking the prosecutor in the presence of all the parties, so it's not an ex parte conversation, whether this person could also be considered a victim. This should get the defense attorney thinking about whether his client has other actions in the role that's being brought before the court. In turn, I would expect that the prosecutor, as the seeker of justice, to answer those questions truthfully and to have looked at that question prior to bringing that case before the court. The rules are really clear. They say that I cannot investigate my personal observation. So if I see someone that looks young, I believe to be barely 18, in this case 17 in a criminal offense, there's nothing that I can do. It says I'm bound to respond to the facts and evidence that they are presented, and that's, of course, unless I am in an accountability court, and then it appears that I have permission for and am encouraged to explore options. I would direct you to 2.9A5, which allows a judge to initiate, permit, or consider ex parte communication when authorized to do so. There were several examples given. That would be in problem-solving courts, therapeutic courts, accountability courts. Unfortunately, the only courts that are actually mentioned are drug courts, mental health courts, and veterans courts. At this point, Georgia does not have accountability courts for sex trafficking. So that would be one of the options. So I would say the first thing is know your role and know what court you are sitting in.
And thank you for bringing to our attention that new exception under the Code of Judicial Conduct regarding the ex parte communications and the more liberal rule available to judges who are working in the accountability court context. Third question also deals with this issue of boundaries, but it has to deal with a view that has evolved probably within the last couple of decades in terms of the role of the judicial officer. There are some individuals who think that you can look at the routine work of a judicial officer and almost see three different phases of responsibility, that the adjudication of legal fault or culpability is one phase of a judge's work, that once adjudication has occurred and the court is involved in some form of remedial disposition of the case, you have a second phase. And then there is a general leadership role that judicial officers seem to have with regards to educating the public about the law or educating and working with other elements of the legal system. If one were to buy into the notion that there are three different forms of judicial professionalism in those scenarios or those domains of activity, do these limits that I referred you to earlier in Rule Point 2.10 and 2.9, do these apply the same across all three of those professionalism contexts, or do they differ slightly, whether you're talking about adjudication, disposition, or working with other elements of the legal system and the public? And I think I'm going to ask you, Judge Kirk, if you might respond to that first.
And I would argue that the canons are in conflict. Under 1.2, Commentary 3, the test for whether or not there is an appearance of impropriety is whether the conduct would create in a reasonable mind a perception that the judge's ability to carry out judicial responsibilities with integrity, impartiality, and competence is impaired. Compare that to Rule 4.2A2, Commentary 1, which permits a judge to state his or her personal opinion, belief, as long as she clearly states, however, given my personal belief, I will follow the law. For me, that gives me pause. If you are feeling that you need to state your personal belief before you tell me what the law says, you can't do those two things in the same breath. Commentary 2 argues that one is prohibited as a judicial candidate from making comments that might impair the fairness of a pending proceeding or an impending hearing. And so the other item that I find of note in this question is there is a specific exception for campaign conduct. I'm not sure when a judge, whether elected or appointed, is not in a campaigning position. If you're appointed, you're campaigning to continue in your seat. If you're elected or facing retention, once you are campaigning until you announce the decision to step down. So to have campaign-type activities excluded, I'm not sure whether that exclusion continues infinitum, because it appears that as long as you can say, I'm in a campaign role, and so I'm going to tell you what my personal belief is, but I'm going to tell you that no matter what, I'm going to follow the law. It appears that the overarching canon for this discussion, Canon 1, actually requires that judges uphold independence, integrity, and impartiality of the judiciary. It says, and shall avoid impropriety and the appearance of impropriety in all activities. I don't believe that you can do both. We are required to respect and comply with the law, but also required to promote public confidence in the judiciary. So I don't know that you can make all of those statements.
Judge Oliver, do you have any follow-up thoughts?
Well, I do think that in Georgia anyway, if you're an elected judge, you're always a candidate. I mean, I'm always campaigning. I was just elected this year, but I'm still a candidate. However, I do feel that one of our responsibilities in the judiciary is to educate the public, and I do feel that we can talk about our experiences and cases that we've dealt with so long as they're totally finalized. Just like Judge Emerson spoke of the case that he had because all of the appeals process is concluded. We can give the statistics that many people have given on this panel throughout the course of the day when we're talking to civic groups, Rotary clubs, Civitan clubs, and bring to their attention that there is such a thing as human trafficking and what it looks like and what the law is with regard to human trafficking. Now, this not giving your opinion, it's when I do jury selection on a child molestation case, the defense always wants me to eliminate jurors because they say, I'm against child molestation. I say, we won't get a jury if I eliminate everybody that's against. That goes without saying. I'm a judge. I'm against child molestation. I'm against human trafficking. I have an opinion on that, just like hopefully, most of the sane people in this country have the same opinion that I do. So I don't even have to say my opinion on that. But I can educate the public on the process of the court, the problems that we're seeing in the court. Now, generally when I'm not talking about human trafficking being a large problem, because I don't see a large number of cases in human trafficking yet. What I'm usually talking about is the problem with drugs and drug addiction. And I'm basing that on my experience and the cases that I've seen over 17 years as a judge, and how that almost permeates every criminal and probably the vast majority of my civil cases. So I think that we have an obligation to educate the public, and that we can do so within the boundaries of our canons of judicial conduct in an appropriate way, giving statistical information and talking about what we see in our experiences from the bench.
Judge Rodatis, would you weigh in on this question as well?
Yeah, I'll give an example. I mean, I agree with everybody said, and I don't consider this making a public statement. In the Gwinnett Juvenile Court, I handle 99% of the abortion bypass hearings, which is a very set standard, whether you can say a child can have that procedure without telling their parents. I have problems with that law, not because I'm anti-choice or pro-choice or anti-abortion, not at all. It's the only example I can think of where a child could have surgery that could result in their death, that we don't have to get their parents' involvement. That's something that I don't like doing. At the same time, and I'm the only Catholic on the bench, so that really makes it complicated, I've never turned one down, because our guardian ad litem's prepare the kids. They know what the answers should be, make sure they know what the answers are about how it could harm them, and I always grant them. But it's always with a little bit of a twinge inside. But that wasn't a public comment. I'm speaking to a bunch of lawyers.
We have about 4 minutes left, so we'll move to our fourth question. Rule 2.8 commands judges to be courteous to all with whom they deal in their official capacity, and its commentary 2, which is a new provision, allows judges to make reasonable accommodations for self-representing parties and litigants to assure them a fair hearing. You heard this morning Judge Herbert and Judge Camacho talk about situations where a defendant was in front of them and the big burly guy was in the back of the room. This was probably an early stage criminal proceeding, self-represented party. Given that the Georgia Code allows for judicial officers to make reasonable accommodations, I ask the panel, in human trafficking situations, can you describe any accommodations of this nature that you think might be necessary and useful or helpful? Judge Oliver, would you care to comment on that?
Well, I would strongly encourage them not to remain self-representing. If I can't talk them out of that, what I can do is appoint a defense lawyer to assist them while not representing them, so that there is some help to the self-representing litigant, especially if it's a serious case, which if it's in front of me, it will be. And again, if they insist on going to trial and there's evidence there that would support the coercion charge, I decide the law to instruct the jury on. And so I can make sure that while they don't have a lawyer that is requesting any charges that might support their defenses, that I give the charges that the evidence supports with regard to any evidence that might be present concerning a defense.
And Judge Kirk, again, you would have this at a different phase in the proceeding. What's your response?
And so my concern with self-represented litigants is the prohibition that the court augment the case. When you are dealing with a self-represented litigant, it is always your desire for them to present the best case that they can, but at the end of the day, it's whatever case they bring before you. You are able to ask them some questions, but you are not able to present their case. In order to assist them in a way that does not bias the other party against you or does not represent negatively as to the other party, the only thing you can do is ask pointed questions specifically as they relate to human trafficking. But I think the judge has to be very careful that they are not presenting the case that they want to see as opposed to the case that that individual chooses to present.
I believe that that consumes our time, does it not? And I think that given the hour of the day, that it's probably appropriate for us to cede the podium to the next panel and to the Attorney General.
Thank you all. We were prepared to indulge you another 4 minutes, so if anyone has any parting comments, they're certainly welcome. Thank you again. Appreciate all of your insights. We'll do a little bit of a stretch break kind of in your place just while we make some shifts up here on stage to welcome up really and to thank very much all of our out-of-state guests to share with us their final thoughts on the day, on the issues, on the work that remains ahead. And so I'll invite up to moderate the panel Attorney General Sam Olens, but we'll bring back Judge Camacho, who you've met earlier in the day, and of course welcome the opportunity to hear more. Also welcome back Ambassador Kopich. Again, always the more we can get, the better off we are. And Danielle Mangaloni, who's our technical advisor, who we also really could learn so much more from. So we will take advantage of their time and their expertise while they are here by inviting them back to the panel. Oh, thank you. And as they conclude the panel, then Attorney General Olens has agreed to give us some closing remarks. At that point, I'd like to invite you to join us for a reception. It'll be back in the atrium, just some light refreshments and wine and beer, just to share and sort of be collegial after such a long and intense kind of day. So please, I hope you'll be able to stick around and join us. But with this, I'm going to turn it over to Attorney General Olens.
Thank you. So before we get into some good questions, I first want to give Danielle an opportunity to comment about the opportunities that the Center for Court Innovation could frankly be providing some of our judges and some of our courts in the state.
Sure. So I didn't really have an opportunity earlier to tell you much about what the Center for Court Innovation is. Have any of you actually heard of the Center for Court Innovation? Okay, one of you. Excellent.
It's a good one.
That's good. That's good that you are aware of us. I don't have a slide behind me, but I do have cards if anybody wants my information. The first thing I would do is check out our website. It's courtinnovation.org. If you look on the left, there are a series of subject matters, and human trafficking is one of them. And if you click on the human trafficking page, we've developed a whole host of resources and tools that are designed to be practical. So things like how to respond to sex trafficking in your jurisdiction, a step-by-step toolkit. It can give you ideas for what the initial next step would be if you wanted to go home and actually do something. Hopefully you do want to go home and actually do something after the summit today. So that's one piece, is this, the tools and the resources that we've developed that are available to you online. And that's at the most macro level. And then widening the lens a little bit, we offer consulting, one-on-one consulting, which is a lot of what I do. So we could visit you. We could facilitate a strategic planning session with a small group of stakeholders if you said, look, we want to pilot something in Cobb County. We're going to get our judge together, law enforcement, service providers, child welfare. We just need an outsider to come in and help facilitate this conversation, help us set up some goals and an implementation plan. That's also something that we can assist with. And then also providing training. So if there was a particular area that you heard about today that you want more in-depth information on, anything from the dynamics of human trafficking and prostitution to What are effective court-based strategies, procedural justice, and what that means when working with victims of human trafficking, effective interventions. These are types of trainings that we could facilitate either by myself or I have a team of experts that work with us at the center. And I should also say, and this is my last point because I don't want to take up too much time, we have worked very closely with the state court system in New York and have developed and now oversee our human trafficking intervention court. So our expertise is based on our on-the-ground experience in New York, designing and constantly enhancing these programs that we've developed there.
Thank you. So Ambassador Coppage, still get a smile when I say that. I knew her when, no. So the first time you had a human trafficking case for U.S. Attorney Yates, you were prosecuting under RICO. And of course, now there's all these new statutes. And there's a whole lot of ideas for proposed new statutes, but they can't get through Congress. What would you tell us from your experience, both international and national, as to what we should be potentially looking to do in Georgia? And I'm saying that not from the perspective of the prosecutor as much as I'm saying it from the perspective of the victim.
So I think, with respect to victims, that we have come such a long way from the earlier cases that we were trying here. I'm so proud of Georgia because we were fighting trafficking early on, thanks to the efforts of our Attorney General, Senator Unterman, that Attorney General Owens mentioned earlier today. We were really in the forefront of this, and you've heard reference to why, and that was juvenile court judge Nina Hickson. So this is a judge who saw a situation in her courtroom that was untenable. The same 14 and 15 and 16-year-old girls being bonded out by the same men. And she wrote an editorial that galvanized the Atlanta community, that shone a spotlight on what she observed every day, but that other people had no idea was going on. And then we moved from that to looking at force, fraud, and coercion of adults. And so our laws, as they exist now, are very generous to fighting human trafficking, both sex trafficking and labor trafficking. So if those laws don't evolve anymore, they're sufficient once we become familiar with what this problem looks like. They're sufficient to bring successful cases. And talking to judges, again, I view this as an opportunity to share with you some experiences so that when you see them, you may remember, and this may resonate with you. I had a case involving 9 young girls and women, ages spanned from 14 to 24, who were brought here from Mexico. And all 9 of them testified differently at trial. It was an example that I use for prosecutors to show you the different types of experiences and different types of witnesses you're going to have. One of them didn't remember anything. Her answer to everything was, no me recuerdo. I don't remember. Okay, that was just how she had coped with it. The youngest, the 14-year-old, when she had been brought in, was 17 by the time the trial happened. She had been trafficked for 2 years, and then it took a year to get to trial. And she had learned English more than any of the other girls. I think the youth are so adaptable. She was finishing high school. She was in a foster care family. And she walked into court in the tightest, shortest dress I had seen in federal court ever. And she walked down the middle of the courtroom by her trafficker because she was proud of all the things that she had done when she had gotten away from him. He used to demean her and belittle her, call her fat. He wouldn't feed her when she didn't work. So she wanted him to see that she was in control. And that attire she had on was her way of saying, I'm doing fine, look at me now. And so that was shocking for the jury when she walked in. And then I had a third victim who came down the side of the prosecution table. The defense likes to say that I sit between the jury and the defense. And so I was shielding her from the trafficker, and she came in, and she sat on the witness stand. She had on a sweater, and she was all folded up on herself, and she wouldn't even look at me when I was questioning her, even though we'd met many times. And so those are just the different reactions you can expect. There is no one trafficking victim. There is no one right way to respond to this crime. And that's part of the victim-centered approach that we keep talking about. And I will say in that case, I found out something that I didn't know, and I don't know what Georgia has for this, but the trial was 2.5 weeks, and the jury deliberated for 2 or 3 days. We had a lot of charges. And one of the jurors clearly had cried the majority of the deliberations. When she came out, she was just a wreck. And I found out from our victim witness coordinator in the federal system, we have resources for jurors who go through a traumatic trial experience. And so I encourage you to do that if you feel like you've got jurors that are being affected by any kind of case. But I want to end by applauding the judge in that case who recognized, he said this at sentencing, that these women were the definition of vulnerability. And by that, he had not viewed them through the illegal immigrant perspective or the bad girl perspective or the witness who changes her story perspective, but he had seen them as preyed upon by the defendants in court. And each judge in this room is in such a unique position to deliver justice, not only to defendants, that we think about a defendant's rights at trial, but also to victims of all crimes. And I hope that this has really resonated with you today and that you'll continue to view these cases through a victim-centered lens.
Thank you. Judge Camacho, similar to Ambassador Coppedge, you were on the first floor. Hopefully you've seen a lot of change since then. You've instituted in New York a lot of change since then. What should we know about the difficulties along the way and maybe some little secrets or pearls of wisdom you have to help us get to that next step?
First of all, today I learned that Georgia gets it, doing great work. Also, thank you to the ethics panel. I often question myself, am I going too far? Am I doing too much? And I think the fact that you said we have a responsibility for leadership. Thank you for that, because we do. Many, many years ago, one of the first human trafficking conferences I attended, there was a quote in an article. It was, more and more children are going into prostitution because of a lack of will to combat it. Initially, when I first read it, yeah, these kids, they don't have the will to combat it. And then over the years, the more I think about it, it's us. That person who wrote that was talking about us, all of us. And the reason we lack the will, the spoken word performance right after lunch, I was cringing. Part of me wanted to cry. Part of me wanted to run out the door because I couldn't listen to it. It's so painful. That's the wall. That is what's keeping people from understanding and appreciating this evil. They don't want to hear it. Put it in their face, right in front of them, make them deal with it. I want to end on a positive note, because this should be positive. I'll tell you the end of the story of that little 16-year-old who walked into my courtroom 12 years ago, who started me on this mission. She got arrested 3 or 4 more times. Her name's Siobhan. Got arrested 3 or 4 more times during the course of her 2 years in my part. She cursed me out at times. She did great at others. And her case ended. She graduated from my program. And she would come back over the years every once in a while. She'd show up in my court. Hey, Judge, I got my first car. Hey, Judge, I got a computer. Hey, Judge, I got my apartment. And I would, hey, Siobhan, how you doing? And then she stopped coming. In a couple of years, she wasn't showing up. And I wondered about her over the years. Where's Siobhan? I hope she's okay. I hope she's okay. I hope she's okay. So I've become the boss of Queens County at one point. So I'm now a big shot. I'm on the top floor and having all these important meetings. One day, my secretary walks in. This woman who's desperate. She needs to see her. I said, Kathy, I'll get to her. I'll get to her. By the time I come out of my meeting, I go out and look, and she's gone, but she left a note. It was from Siobhan. Hey, Judge, I just wanted to tell you that I'm alive and I'm doing great. And she tells me all about what she's doing. And she just ends it very simply by saying, mostly I just wanted to tell you I'm okay, I'm good. And I think I started crying right then and there. I said, Siobhan, I always knew you were good. And then I lost track of her again over the next few years. And we had a celebration last year before, 10-year anniversary of the part, and I attended. All these dignitaries were there. And they ended the program, and they have a special guest for Judge Camacho. And in walked Siobhan with her 2-year-old son and her husband and her mother, who she hadn't seen for years and alienated from. And I gave her the biggest hug, and And you know, that, and she's telling me about herself, and I'm playing with her little 2-year-old boy, and I'm thinking, I didn't realize, and the mother tells me, Judge, I want to thank you, you saved my daughter's life, and I didn't get it at that point. It only struck me sometime later. I was speaking to a group of nuns in a convent who had a program about this. I go anywhere. You want to talk about trafficking? I'm there. And I'm thinking about what I'm going to say to these nuns, and I'm thinking about what that mother said to me, Siobhan's mother, about how you saved my daughter's life, you saved her. And I thought to myself, here I was, a middle-aged former homicide prosecutor judge who was playing let's make a deal and throwing little kids in jail, and then I met her. Who really saved who? Who really saved who? So keep up the great work.
I want to open up to the three of you for what we should potentially be doing better to protect these young children before trafficking occurs. Any ideas that any of the three of you have?
End poverty, homelessness, child sexual abuse.
Job skills and training. I think outreach through schools is a cutting-edge area where we're moving. Department of Education has programs where they're trying to get the message out to youth to warn them about some of the tactics that traffickers use. So I think that's a good warning the very people that are going to be approached.
I think getting into the schools is huge, but it's something I mentioned earlier, I think, is the big, none of this is going to happen. None of this is going to happen unless we go out, and since you go out, not judges, because judges, well, you know, I speak, thank you for that as well. I'm allowed to go out there and talk to the community about, and show some leadership, talking about, see, we're in the front lines. We judges, we see it. It's right there. We can't avoid it. So we have an obligation to go out and talk about it, explain it to the community. I think it's about changing, like I said earlier, changing hearts and minds so people don't say, these are prostitutes who like what they're doing. Start having them look at the little girls that they really are, the victims that they really are.
You know, probably about 6 or 7 months ago, Kamala and I went to D.C. for, I forget, something. It's a commission on human rights on sex trafficking. It's nonpartisan, some congressmen, some senators, and they had about 5 of us on a panel. They had a lady that was born in D.C., trafficked as a child, runs a house in D.C. now. And she gave a story about the little girls telling her open knees means food in the refrigerator. And the fact that she was told that if she opened her knees, which meant sex, that the money that she was given would then be able to be used by her mom to buy food for her and her siblings. And there was really nothing, frankly, more startling in that testimony that day than the comment about open knees. I mean, we were talking 8, 9, 10-year-old girls that were instructed that if you were going to have adequate nutrition in your house, this is how you accomplished it. And I think that's why it is so important that we have a serious discussion with our juvenile court judges, because as Judge Camacho mentioned today, and as I've heard him mention earlier, there is so much we can stop when they're really young. And at the point that we're in Superior Court, we've wasted way too many years. So I clearly just commend Judge Camacho and all the juvenile court judges. You know, commend is a word you use loosely, but for a juvenile court judge in our state to see these young kids and to see them for what they're already going through and to make a change in their lives, to seek to make a change. You know, it's too late when the prosecutor's involved. It's too late when the judge is involved. The damage is done. And for the judges to catch the opportunity they have to save these kids' lives so early, to me, is, in essence, my closing. And also, I think what's so important about many of the folks we've had the honor to hear from today. The only last thing I would say is we need to thank the state Justice Institute too for all of their assistance with today. There are evaluations outside. We would like you to complete the evaluations. They will be seriously reviewed. There is a desire to learn from this and to see what should be done thereafter in regard to further assist our judges with these types of cases. We want to thank the 3 panelists from the last panel and for y'all coming down, traveling to Georgia. We're nowhere near the hurricane. You're still safe. Thank God for the folks that are on the coast. We hope they're all safe. And thank you all for coming.
Thank you.
Good afternoon, everybody. I'm Michelle Barkley with the Administrative Office of the Courts. Before we go to the reception, can you all just join me in recognizing Carlise Greer, Bruce Shaw, and Regina Roberts? They've done a ton of work on this. And on behalf of the state courts, thank you to the Attorney General's office. We couldn't have gotten this grant without you.
Thank you.
And I look forward to seeing you out at the reception.